You can't represent yourself at the Supreme Court anymore. But why not? The last case argued by a non-lawyer was almost 50 years ago, the Securities and Exchange Commission versus Samuel Sloan. Sloan was suing the SEC after they stopped all trading for a mining and paper company called Canadian Javelin. Sloan was a shareholder in the process of shorting the stock. To understand where things went wrong, we have to go back in time. In 1949, Joseph Smallwood led Newfoundland and Labrador to join Canada, and he would serve as their premier for 23 years. In the 1950s, Smallwood was impressed by the work of a mining entrepreneur in Labrador named John C. Doyle. His company, Canadian Javelin, was plagued with securities violations, trading stop and start, but Doyle continued to sell stock certificates.
We were dealing with people who were fugitives from justice. We were dealing with both foreign and domestic marketplaces and the effects of manipulations in both marketplaces.
According to one story, when two FBI agents came to question him, Doyle charmed them into buying stock. After an indictment in 1963, there was a New York Times story that the board backed Doyle. But 2 years later, he was forced to resign and flee to Canada, where he somehow got reinstated. Still in financial trouble, Doyle decided to start over with a paper mill, setting it up on a former military base in Newfoundland. Annual reports told investors that Javelin's mill could ship cardboard to locations around the world. Premier Smallwood made it possible in exchange for the government to have majority control of Javelin. There was more trouble on Canadian and American stock exchanges in 1972, and by the end of 1973, the Canadian police charged Doyle with hundreds of counts of fraud. Doyle evaded the law again and moved to Panama for the rest of his life, continuing to receive millions from Canadian Javelin over the next several years. His friend, Smallwood, faced legal consequences into the 1980s. So, what does this have to do with our case? Born in Virginia, a dropout from UC Berkeley's math department, and then a stockbroker, Samuel Sloan met Doyle in Panama and decided that his new independent brokerage would short the stock. In April 1975, the SEC halted trading of Canadian Javelin due to this mismanagement that I've described and the missed financial filings. They used an emergency 10-day hold and kept reissuing that emergency order to stop all trading for over a year.
Acting under this authority, the Commission twice issued a series of consecutive 10-day orders suspending trading in the common stock of a corporation for over a year each time.
Sloan and other shareholders lost their chance to trade the stock or to have a hearing, which led to the SEC investigating Sloan's business and barring him from trading. The justices unanimously agreed with Sloan that the SEC misused their temporary halt. If Sloan was correct here, what made this the last pro se argument to the court? First, we already know that Chief Justice Burger did not like having courts open to non-lawyers, including writing a dissent in Ferretta v. California a few years earlier.
The prosecutor might be overjoyed at having a defendant waive counsel.
He confronted Sloan on the record about breaking protocol when he arrived at the court.
No, I haven't received anything since the time. It was 1 week ago that I was advised that I would be allowed to argue. I haven't received anything.
Nothing?
No.
March 1st letter you have not received?
No, I have not.
Justice Brennan and his clerks recorded extraordinary hostility toward Sloan in their notes. According to an article in the New Republic, the Chief Justice had tried to reject Sloan's case just a couple of weeks earlier during the Justices' Conference. Burger would remain Chief Justice until 1986, but there was never a return of a non-lawyer to the Supreme Court. What happened? Several people have tried, most famously Larry Flynt in 1983. When the next case was called, Flynt tried to speak, shouting that the court denied him the counsel of his choice, with some shocking profanity. Though many have looked for it, the incident is skipped in this blip on the audio record.
We'll hear arguments next in Calder against Jones and Ingalls.
After Flynt died in 2021, his FBI file revealed that he had discussed violence to disrupt the court. In 2013, Stephen Levin brought a medical malpractice case, which he had argued pro se at lower courts, heading up to the Supreme Court. This forced them to make a decision where it formally banned non-lawyers. That's currently in effect today. As I mentioned in an earlier episode, It has become rare even for lawyers and officials to represent themselves during the Roberts Court. There were 2 cases in 2006 and 1 in 2019. But there is still some hope for the little guy in today's Supreme Court, just with an appointed counsel. Kim Millbrook sent a handwritten appeal from prison to the court and won with his case in 2013. William Wooden composed an appeal on a prison typewriter in 2020 and won. So what happened to Sam Sloan after winning at the Supreme Court? The SEC had still forced his brokerage to close.
So even though I was 100% right and the Securities Exchange Commission was 100% wrong and the United States Supreme Court ruled in my favor, I was never able to get my securities license back again.
After making his argument in March, Sloan headed from D.C. to travel through Afghanistan and Pakistan, the wildest parts of the so-called Hippie Trail. The New Republic relates a story that he first heard about his victory at the court from the U.S. Embassy in Pakistan. That October, his first child was born in New York City, and he married the mother a few days later. Usually I do a section about what happened with the pro se lawyer after their case. I thought a lot about how to include Sam Sloan's story. One way is to let his websites and Usenet posts and public access TV shows control the narrative. Another path is to say he has a felony for parental kidnapping, which he has kept sending to the Supreme Court for 30 years, and his family members deserve privacy. I do want to include some sections which are relevant to the public sphere. Let's fast forward to 2020. In that year, he went to the New Hampshire Democratic primary and also challenged Alexandria Ocasio-Cortez for her House seat in the Bronx. Sloan appeared, but to submit a written statement for the debate. He also tried to run for Congress in Virginia, but was rejected due to his felony. Sloan has been a skilled chess player throughout his life. In December 2023, he participated in a tournament in San Francisco. In January 2024, he appeared on the ballot again in New Hampshire, but this time on the Republican primary. This also gives his location as Oakland. He received 7 votes. United States Supreme Court rules and practices have changed since these cases. This was a podcast episode, not legal advice.